Welcome to the penultimate session of this year's Animal Law Conference. Very glad that you are here with us today to talk about new developments in litigation and legislation. As you probably anticipate, I will open this session by reminding you, if you are seeking CLE credit, you should sign in on the sheet outside and be sure to sign out as you exit. And certainly, you should rate this session, as well as the other sessions, on your Mobi app. That's not only useful in terms of this year's event, but it's useful for feedback for future years, and that's particularly helpful as we go into next year's 25th anniversary event. So tell us how the events are striking you. And with that, we'll move on to the thing that you are all here for. And I'm very pleased to introduce the panel. I'm David Rosengard. I'm the Animal Legal Defense Fund's Criminal Justice Fellow. And I'm moderating the panel, which is composed of Chris Berry, who is the Animal Legal Defense Fund staff attorney in the litigation program. Chris focuses on civil litigation issues, and you're going to hear a lot of exciting stuff that he has insight into. And Sara Amundson is the Humane Society Legislative Fund Executive Director. Prior to that, she was the Deputy and Legislative Director for the Doris Day Animal League, and amongst the many animal issues that she is passionate about are, in particular, research and testing issues involving animals. And so with that, I will turn things over to Chris.
Thanks for sticking around to the very end. So I'm going to focus on the litigation component of the title, and Sara will do the legislation. And this will just sort of be an overview of like what I think are the most important or noteworthy cases that have been decided or resolved over the last year. And I see people like associated with a lot of organizations here, so if I don't leave, if like your organization did something and I left it out, like I'm very sorry. It's very stressful actually. So no slight intended, but I do think there's a good sample from a wide berth of different animal law topics, and also from a variety of different groups and issues that are pretty interesting. And just as a preview, I'm going to be categorizing things into like 4 different categories. So the first category of cases that I'll talk about are ones where advocates are applying animal protection laws directly to the animal, and those involve applying like an actual animal protection standard, but then also having the procedural right to do so. And so there'll be 2 cases on that. One case that I'll talk about involves just empowering activists to advocate on behalf of animals. And then a third category is cases that really elevate the status of animals and are building a foundation where I think the status can be elevated even more over time. And those are, I think, really, really important category of cases. And then lastly, I'll discuss a few where there was an impact, even if it didn't directly relate to some sort of animal welfare or animal advocacy concern. These are just a few cases that I'll mention at the end where litigation was used to have an impact that indirectly advances animal interests. So with that, we'll start with this first category of actually directly applying animal protection laws. And that's the Cool v. Sellner case. And if anyone was in the wildlife panel that just got over, you heard a little about, this is the Cricket Hollow Zoo case that Jessica was talking about. So I'm going to just spend a few minutes on that because I think that this was a really important case. This is the first time that the Endangered Species Act was applied to protect animals that were in captivity. And there was a lot of really interesting stuff that came out of the case as well. So these are just a few pictures of the zoo that I pulled. There were a lot of animals there. They were in small enclosures, inspection reports showing that there was waste buildups. The veterinary care was lacking. In fact, per animal per year, this facility only spent $33 on veterinary care, and there was also a lemur there lemurs are primates, social animals who was housed alone without anyone from her species. So these are this is one of the ring-tailed lemurs. A lion you can see with some problems going on with their nose, and then we've got a tiger here as well, and just a dilapidated roadside zoo in Iowa. So this was an Endangered Species Act case, and the Endangered Species Act just generally says that it's unlawful to take any species, and normally this is done to prevent people from like capturing or hunting or doing something to disrupt wild animals. It's really, normally the litigation is used as a sort of a species and environmental protection. And this is the definition here: harass, harm, pursue, shoot, etc. So there's nothing in the law that requires it to be applied to try to preserve a species in the wild. And in fact, harming an animal, if you have an endangered animal, you're keeping her in captivity, that doesn't take a lot of imagination to see how that could qualify as a harm. So what was effective in this case is we pointed to the Animal Welfare Act standards. The Animal Welfare Act doesn't have a citizen suit, unlike the Endangered Species Act. So you can never sue to directly enforce the Animal Welfare Act, but we pointed to the standards falling short of Animal Welfare Act as evidence that this was a harm and harassment under the Endangered Species Act. And ultimately the judge agreed with us. Importantly, social isolation of a primate was found to be like harm or harassment, which is something like a right to have some sort of like social and mental enrichment. Inadequate sanitation and inadequate veterinary care. So these all rose to the level of a take under the Endangered Species Act. Now, in order to, and that's I think sort of like the high picture takeaway, but there's a few other interesting things in the case. In order to get to the merits, you have to prove standing. And just as a refresher, standing means that you have to have some stake in the litigation. Like, they don't just let anyone come to court with a grievance. You have to have some sort of harm. And so the Endangered Species Act has a citizen suit provision. Anyone can commence a citizen suit, but they still have to satisfy the standing requirement, which means that you're actually injured and it was caused by the activity that you're complaining of, which will then cease if you get the relief that you want. And the judge found that we did have standing. The Cricket Hollow Zoo plaintiffs had an aesthetic injury, and aesthetic just means that it's sort of like harmful to your senses. And the people who we sued on behalf of that actually had like a Facebook group where they were like, "This is a bad facility, we want it to shut down." They regularly went there, well before litigation was even contemplated, and sympathized with the animals, but also wanted to observe their conditions, and that was enough to confer standing. So that's a really great precedent that people who care and have a sort of a personal investment in the welfare of the animals that they're interacting with, that they have standing. Now, another really interesting aspect of this case was the remedy. So, right, sure, you show a violation of the law, but what is there? What does that actually give you? So you can imagine, I'm just quoting some court text here in case people are having fun reading that, but you can imagine like the remedy could be like really basic on one level for injunctive relief. It could just be like, stop violating the law, right? You keep all the animals, but you're ordered to clean up the cages a little bit more often and to give a friend with your with like the solitary lemur. And we ended up getting more than that, where the judge said, like, I don't think that you're capable of having these animals and keeping them in captivity without violating the Endangered Species Act, so ordered that those animals actually be removed. We wanted the judge to go even further and to specifically order the removal to a sanctuary that had a highest GFAS accreditation, but basically a very high standard of accreditation, and where we fought the judge's refusal to do that, and we're still fighting that on appeal. That's just another enclosure with the wolves. Now, just a couple limitations of using this approach. Of course, it only applies to endangered species. These wolves had wolf blood in them, and the judge said that they weren't endangered species. There were other animals there that were not endangered species. I think it was just the lemurs, the lions, and the tigers ultimately were protected by this. And another just interesting takeaway here is just how I think ridiculous it is that the USDA, which is also regulating this facility under the Animal Welfare Act, was regularly citing them for violations, but not actually doing anything about it. Another case that I want to talk about here is the New England Anti-Vivisection Society versus Fish and Wildlife Services. This is another Endangered Species Act case, but sort of a different outcome. In this case, chimpanzees are basically being retired from use in federal research. Federal government's not funding research on them anymore, and now they're protected by the Endangered Species Act, which means that you have to get a permit before you can even test on them. So the Yerkes lab has chimpanzees. They're going to send them to a zoo in England, have to go through the Endangered Species Act requirements to do that. And Neves, the Neves Coalition, they argued, that sending chimpanzees to a zoo doesn't help them at all. Doesn't propagate their survival, and it doesn't enhance their survival as a standard, and that it also actually harms the viability of conservation for chimpanzees because it promotes them as commercial commodities and shows that these are objects that you can acquire and bring into your zoos and show to people. So the merits of the case were actually very strong, and the argument that the plaintiffs made was that this, because this was violating the enhancement of the survival standard, and also there were some procedural problems with it, that the chimpanzees, probably shouldn't go. And the court said that even though these were persuasive arguments, they didn't have standing, and just went through and explained they didn't have informational standing. The court didn't think there was an obligation to provide information relating to these permits, that the agency failed to do, that there was no static injury because the people hadn't bought plane tickets to see them in the zoo. They had workers as plaintiffs who had an investor relationship, claiming aesthetic standing, but since they hadn't actually purchased tickets to go see them in the new zoo in England yet, that they didn't have standing there, and also that Neves didn't have standing as an organization. Neves had argued that, well, we advocate on getting chimpanzees into sanctuaries, and now we're having to do all this work because of the illegal conduct of Fish and Wildlife Services, and sort of not giving the proper review to the survival issue and to our arguments, and there were some other shenanigans as well where the Yerkes lab wanted to just pay off a couple $100,000 to some women's rights group, which was great, but it really didn't have anything to do with promoting survival. So the whole scheme seemed illegal, but they couldn't do anything about it. So that's sort of a counterexample, and shows that it's really a struggle to achieve standing. Even when you have a standard that could, hypothetically, you could find someone with standing, it doesn't mean that you actually do it, or that the judge is going to agree that you have standing. So that's sort of the first category. The second category of cases here, so those are just the different forms of standing that the court found that they didn't have, despite having an argument that these chimps shouldn't go to the zoo. So the second category is helping activists, and this is an ag-gag case. If you were in the First Amendment panel, which I was not, I'm sure Justin talked about it. So Wyoming passed a law to prevent people from basically to counteract environmental groups who were collecting water from public rivers, testing it for E. coli, and basically demonstrating that cattle rancher excrement was getting through the waterways and contaminating it with E. coli. So in response to this, Wyoming passed a prohibition on going on land to quote, collect data resources. And this is part of a larger movement by ag interests known as ag-gag, which I bet a lot of people have heard about. Essentially, instead of ceasing the contamination of water with E. coli, the strategy is to prevent people from being able to prove that that's happening, or to, in other cases, to prohibit people from, failing to disclose they're an animal rights person when they apply for a job at a factory farm to document conditions there. And so this is the unlawful collection of resource data law, and it's just at a very high level of generality. If you enter into private land to collect resource data without authorization, then you're violating this law, and there are criminal penalties attached to it. So the constitutional challenge was that this violates I think most pertinently, that it violates the First Amendment and also the Equal Protection Clause. It violates the First Amendment because it's basically criminalizing the collection and recording of data with the intent to publicize about it and to do political advocacy around it. And the equal protection argument in general is that this law was passed specifically to stifle speech from a political group that the legislators in Wyoming didn't agree with. And so that challenge was brought. The judge ruled against them on both grounds, saying first that there was no First Amendment right to trespass on private property to collect data, which strikes me as a very gerrymandered way to frame this issue. The argument isn't necessarily a right to trespass to collect data. It's the fact that it's criminalizing the collection of data above and beyond the trespassing. And there are already laws that prohibit trespassing in Wyoming. So there's really no reason why that law couldn't just be applied to these trespassers. What they're doing is they're adding special penalties for recording data. And that's really, I think, what the issue is the recording of this data, is that speech, and particularly when that's done to facilitate, and with the intent of facilitating publication and news media and political advocacy in the form of lawsuits or other advocacy. The judge also, in the overbreadth challenge, right, this is maybe the standard is so broad that it might infringe somewhere on the side of speech. The judge didn't think there was a realistic danger of the law resulting in a substantial suppression of speech. And again, the criticism there is not really struggling or grappling with sort of the recording of data as speech and the intent to publicize that as speech. And then also that there's no equal protection concerns due to viewpoint discrimination or animus against the environmental and other groups. And what was really interesting there is that the legislative history for the first bill had a lot of evidence of animus. And after the plaintiffs won their first motion to dismiss, the legislator went back and amended the law, but they were careful not to say in the microphone that they were doing this to stop eco-terrorists or whatever crazy labels they were using. So the judge looked only at sort of the wiped legislative history in this analysis. And there's other ag litigation going on now. We Coalition won an ag suit in Idaho, and that's on that Ninth Circuit Court of Appeals now. So that'll be coming out next year. I think that decision will be, Utah. There's a motion for summary judgment at the district court level later this month, and then North Carolina is another ag law that's recently been challenged as well. So there's a lot of stuff coming down the pipeline. Now we have a couple more cases, but I only have a couple minutes left. Barking Hound Village v. Monyak is in this third category of elevating the status of animals. And this is a companion animal damages case. And this has been a really interesting area of law over the last decade or so. Under the common law for property, you're limited in a tort action. If someone destroys your property or steals it, you're limited to usually to the market value is the way that we assess the value. But for an animal, even at a pet store, it might be $1,000. If it's a rescue animal, there's really no resale market at all, and in fact, millions of animals who are unwanted die. So their market value is essentially zero. And the question was, this family had boarded their dog, and the boarding business negligently gave the dog the wrong medicine, which caused renal failure. The family spent over $60,000 trying to save the dog's life, but the dog ultimately died anyways. This was like a 9-year-old dog that had been with the family for a long time. So they sued. And the question was, how much money can they get for it? The other side was the defendants were arguing for a fair market value cap, right, which would essentially limit the value to like 0 or 1 or maybe $100 if you're being generous. And in contrast, the family was the family and some animal groups, including ALDF, who did an amicus brief in this, were asking for the actual value to owner. And of course, if you know tort law, the point is to make you whole, to compensate you. So really, it was between the actual value or the less than actual value. And ultimately, the courts, it was mostly a victory. The court said that you could recover your veterinary expenses. Now, you can do this with a car. If someone totaled your car, $1,000 car, it costs $20,000 to repair it, you would just get your $1,000 back for your clunker to buy a new clunker. You couldn't spend $20,000 to restore it. So, but the court said that, in this case, that doesn't apply to pets, that you can get reasonable veterinary expenses for your pets, which was good, which means that they could get some or all of that $60,000. But the court fell short of that and said that beyond that, you're not able to do any more. Sentimental damages might be an example of something that, a form of damages that are not really economic that you'd still want to be compensated for in order to receive the actual value of the pet. So sentimental damages, like in a lot of states, you can get it for like a family heirloom. Might only be worth maybe it's worth $5,000 or maybe $500, but because it was from your great-great-grandma, to you it's worth $5,000. So that would be sentimental damages. And this court said that you can't get anything like that. So there's still a lot of, this issue keeps coming up. It'll keep coming up as other states revisit this common law rule, and we'll see where that goes. And then the last case, I know I'm out of time, but
I think you've got some extra time.
I can steal a couple more minutes.
Yeah.
Great. So then the last case, State of Oregon v. Newcomb. This is another status elevating case that's really important. And essentially the facts here were that a dog was seized, visibly malnourished, seized by, I think, animal control or law enforcement. And then subsequently, veterinary tests were done to see if there was some sickness affecting the dog that the veterinarians wanted to know about so that they could treat. And the issue there was whether that draw of blood was a search. It was actually a search under the Constitution, and so the issue was whether that search was constitutionally permissible or not, based on the interest of the animal. And I actually would like to. David works in criminal law, so I want to cede it to him for a minute to my Fourth Amendment search and seizure law is not up to snuff. So do you want to just take it over from me?
Yeah, I can jump up and talk about Newcomb. Thank you. So that was a great setup for Newcomb. Again, the issue is we have an animal that's been lawfully seized, so we have no seizure issue, but we've got a blood draw, so we've got a search problem. And this is significant because at trial, in this case, as so frequently happens in neglect cases, one of the defense arguments was, the reason my dog is incredibly underweight is not because I'm not feeding it, it's because the dog has some other illness. And the blood test, of course, was very helpful for the prosecutor to show, no, the only thing wrong with your dog is no one's been feeding your dog. And the defense attempts to analogize Juno, the dog, to a container, and argues that in the same way that in the state of Oregon, under our specific state constitution and more broadly under the Fourth Amendment, you would need a warrant to open up and search through someone's container. You need a warrant to see what's in the dog. And this wins its way up to to the Oregon Supreme Court, and the Oregon Supreme Court rejects that argument. The Oregon Supreme Court holds that, in fact, the blood draw was legitimate. And in doing so, we can talk more about Newcomb if you have questions. I'm happy to get into it at length, but I want to pull from that case a few practical lessons and a few jurisprudential and strategic lessons. So practically, what we get out of the Oregon Supreme Court's ruling in Newcomb, which again was that the blood draw was a permissible activity, you didn't have to throw out that evidence. The first thing we get when we look through both the Supreme Court's decision as well as the appellate court's decision is that as we enter an era where technology makes getting search warrants increasingly easy, it is a good idea. If you think you might have to be doing something that might require a warrant, and you can get one, get the warrant. This is sort of the dog version of the US Supreme Court's decision in 2013 in Missouri v. McNeely, which was a human blood draw case. If you need a warrant and you can get one, get one. If you think you might need one and you can get it, get it. In this case, the people doing the blood draw, the veterinarians who were working for the Oregon Humane Society and were therefore agents of the state, didn't realize they might need one because it had never come up before. But it's a good moral for us to err on the side of safety. The other practical lesson here is that, at least in terms of precedent in Oregon, in terms of persuasive argument elsewhere, if you are doing a blood draw on a lawfully seized animal for the purposes of diagnosis or treatment, then that is not a Fourth Amendment search and seizure issue. If you're doing that blood draw because you want to support specifically prosecution, then that would be a search issue. But the court also had some other concerns about, well, what if there was a microchip that the dog had with secret messages on it, and you're trying to scan that, that's probably a search. We don't need to go there. So, the jurisprudence and the strategy, what can we draw out of Newcomb? So one of the things that is important to pull out of that decision is, to paraphrase the actual language of the court, sentience is a distinctive fact that makes a legal difference. Animals being sentient matters, and it really mattered in this case. One of the things the court was grappling with was that Juno is not the same as a briefcase. It's not the same as a backpack. Juno is distinct from an object. And the sentience attached to animals is what made the difference in that case, and what made the difference in the outcome. And this gets us to a useful strategic lesson, and it has to do with the utility in how we frame these issues. We often hear in animal cases the refrain from opponents of the animal movement that if we increase the status of animals, that will cause animals and humans to be equated. Mere anarchy will be loosed upon the world, the floodgates will open, and who knows what will happen. The Oregon Supreme Court does something really interesting in this decision. They say the issue here is not that the law draws distinctions between humans and animals. We're not going to go there. We're not going to talk about that. We're going to focus on there being distinctions that are legally supportable and, in fact, legally implicated between animals and all other kinds of property. And that is a really useful way to frame that argument, because it lets you advance Juno's interests, the interests of other animals, without having to grapple with that other issue in front of the court at this point in time. And that ultimately brings the court around to the notion of an animal's well-being and how you weigh that against privacy interests. And the court ends up saying something really interesting. They're talking about the notion that in Oregon, you've got a statutory duty if you have custody of an animal, whether you own it as Juno's owner or whether you just have it in your control, as the state did when they seized it. You have a statutory duty to provide a minimum level of care for that animal's well-being. And the court says that an animal's owner simply has no cognizable privacy right that can outweigh that obligation. Now, let that sink in for a moment. Privacy right is a fundamental right. And what we're being told is that there's a legally recognizable interest in the animal's well-being that can outweigh that in some circumstances. And that's huge. That's like giving me goosebumps. Huge. And it's worth noting that is something that we've got being built on at this point in time. There's a separate conversation about who that obligation resides with, and it ultimately resides with the person having custody, so it's not actually a right associated with the animal. We'll talk about that later if you'd like. But this gets me to the last point I want to make about Newcomb, and that's that in reaching this decision, in looking at sentience, and looking at the obligation to provide for an animal's well-being, one of the ways the court gets there is really to rely on legislation and to rely on a body of statutes that's been really deliberately built up by the work of ALDF and other animal organizations to build sentience into Oregon's code, to build a recognition of animals as distinct and different. And that's what helps the court reach this decision in this place. So this, to me, strategically, beyond the bounds of the courtroom, speaks to the importance of being able to connect cultural change, the sort of stuff we heard yesterday in terms of the food conversation, with legislative change, giving us better litigation opportunities, giving us better environments to litigate in. So with that, having focused you on the importance of legislation, I'm going to turn things over to Sara. Or did you have more, Chris? I don't want to cut you off. Yeah, Chris will wrap up, and then we'll go to Sara.
I'll just conclude really quickly. So those are both, I think, status elevating cases that are really important because they're showing animals as being something more than property. And so that's fits in a lot into the animal rights paradigm as opposed to the animal welfare paradigm. And it's really, I think, consistent with it. And this is a precedent that will be cited in more groundbreaking animal rights litigation in like the years and decades to come. So I can't stress enough the importance of animals being more than fair market value or animals' interests outweighing someone's constitutional privacy interests for purposes of Fourth Amendment analysis. So that's all that I have, and I'm happy to turn it over now.
I need to find my slides. Thank you very much. Well, in the meantime, I want to thank ALDF, as always, and Lewis and Clark, the animal law section. Thank you. This is flat out my favorite conference to speak at because you folks are so well versed in so many of these issues to begin with that it really allows us to dig deeper and also in some cases provide some background that may not be all that public in nature. And so instead of a rote presentation on existing federal animal protection legislation and regulatory activity, I'm going to blow through some of these slides and really focus on digging in what transpired in 2016 and what we can expect in our lame duck session. I'm also going to talk about the power of the presidency, and I'm sure a lot of you are doubting what that means these days, but trust me, we have got a track record with the Obama administration that bears taking a few minutes of notation, so thank you for that. On federal legislation, you folks are familiar with the Humane Cosmetics Act. This is a House-only bill. It is building in stature in terms of co-sponsorship. What's important here is that there are rival bills that are being introduced that would create more of a rubric for the cosmetics industry to actually be regulated. Part of the argument has been the 1938 Food, Drug, and Cosmetics statute has not been updated in the cosmetics area since 1938, and it's one of the reasons why there's so much latitude in this area. In an interesting development, there was a U.S. Senate hearing on a Feinstein-Collins bill, and both of those senators are huge friends of the animal protection movement. The hearing took place fairly recently, and lo and behold, we were surprised to discover that the cosmetics company testifying in support of the bill was Jack Black. What's important about Jack Black? They're cruelty-free. Wonderful way to be able to knit the dots together and help the industry the environmental organizations supporting the bill and also the U.S. senators understand that you can have a clean supply chain that provides for public health without utilizing new animal testing. Many of you know about PAWS. This is so important in terms of more than 80 million households having pets, and some percentage of those households are individuals, primarily women, but families and otherwise, who are experiencing domestic violence situations. And be that the case, we want to ensure that as Red Rover and other networks build out to allow for sheltering opportunities to ensure that victims of domestic violence get to include their pets as their companions, and members of their family are allowed to cross state lines to make that happen. This bill had a hotline in the U.S. Senate just prior to the break. Now, what does that mean? It means that it's non-controversial enough that both the Republicans and the Democrats were willing to go without a recorded vote and the process to achieve that in the U.S. Senate. And in an interesting twist, and please do not blame either party, it's a very ugly, ugly time in D.C. The sponsor of that bill, leading Republican, is Kelly Ayotte. And for those of you watching politics, she is in a very heated U.S. Senate re-election race. That meant the Democrats were not going to give her a win. And so the hotline ran, but it was not accomplished. We have commitments from both sides, both parties, both caucuses, that this is a bill they expect to be able to clear in the lame duck. PACT, same sort of situation here, folks. So who's the lead sponsor on PACT? Who hotlined it in the Republican caucus? Senator Toomey from Pennsylvania, who's in a heated re-election race. And we wound up with the same scenario with the hotline. But again, recognize that the commitments are there, and these are two bills, potentially, that could clear the U.S. Senate chamber during the lame duck. Folks know about AWARE. USDA has taken steps to deal with it. PAST is incredibly important because of the interplay between the federal legislation and the current proposed Horse Protection Act rule. That rule takes steps to actually initiate much of what the federal bill actually does to ensure that the stacks and devices, and I say devices nicely because those of you who know what horse soring is recognize that it is utterly criminal activity in the form of the most abject, horrendous animal cruelty I've seen that is sanctioned in show rings. In fact, I've got videotape, you'll see it too, of a horse that went down in an Asheville show ring on Friday night that was so sored it was impossible to not note through an inspection process prior to that horse going down that that was the case. SAFE, clearly continuing to add co-sponsors, but the important thought there is both the House and Senate full appropriations committees put the kibosh on USDA being allowed to actually have funding to inspect horse slaughterhouses should they reopen in the United States. I want to spend a couple of minutes on two bills, House and Senate, that became actual law this year. And the importance here is TSCA reform, or the Toxic Substances Control Act, is a 40-year-old statute which regulates up to 80,000 chemicals in commerce here in the United States and clearly around the world. 80,000 chemicals, just one animal test for carcinogenicity utilizes just 800 animals, mice and rats, takes approximately 2 years and $4 million for results that never get used to regulate chemicals. Multiply that by all of the other safety endpoints for a risk assessment, and you'll note the animal death count, in addition to the cost to the chemical industry, and the lack of oversight of the federal regulatory authorities led to a failed system. We were incredibly fortunate to work with our good friend, Senator Cory Booker, on crafting the most intensive, far-reaching language on animal testing now in any U.S. federal statute, which requires that the industry utilize all available federally approved alternatives, whether they be approved by the OECD, so internationally, here in the United States, or they be simple strategies that reduce the use of animals. These strategies and these test methods will ultimately completely replace the use of animals in chemical testing. We had support from some very key players as part of this process, as you can imagine. Some of them are listed here. Shout out definitely to Senators Tom Udall and David Vitter, and believe it or not, Chairman Jim Inhofe, who hasn't met an animal protection issue he likes, but on this one was on solid ground with us through the entire process of negotiation with the House leads. We even brought on environmental protection organizations, and I know you're all looking at me because you work on wildlife or other sorts of related issues through the Clean Water Act or the Clean Air Act or all of the wonderful environmental statutes that actually have standing in them. But what I'm telling you is that environmental protection organizations have been no friend of animal protection organizations on chemical testing issues because they think we're putting animals over public health, and nothing could be further from the truth. Those carcinogenicity tests I just told you about, what's the predictive value? About 50%. That's like flipping a quarter and saying, this use of animals has predicted, in essence, this chemical will or will not be a carcinogen. It's sort of an unusual situation. But we did ultimately have the Environmental Defense Fund very strongly in our corner and Environmental Working Group. This tells the story on this issue. And the truth is, we had Democrats in the House who objected to this final language being included in this statute. And it was really on the basis of a political chit versus having any substance whatsoever. But it became, frankly, a holy war. We were told the last weekend before the final negotiation on the reconciliation of those two bills that this animal testing issue was one of 3 remaining issues to be decided. How unusual is that? And it really required us to go to the press to demonstrate that this had broad support, even from the current EPA Assistant Administrator responsible for oversight of this particular statute. And so in the end, we were fortunate and did prevail. There was a White House signing ceremony. It was a very exciting time to see all of these stakeholders come together, but it was very difficult to get through. The Obama administration, so 7 years and 3/4 or so, we are looking at the most progressive administration any of us have been party to in terms of animal protection issues. Approximately 35 major decisions have been made through executive order or final regulations, and there are many more on tap yet to come. And it's the plethora of issues, too, that makes it so utterly distinctive. It's wildlife trafficking and downed calves and pets and pet food, and apparently Donald Trump doesn't think the FDA should be regulating pet food. But for those of us who know about the 13 strong incidences that were reported this year, we recognize there is certainly a role to be played. And it really is a scenario whereby when you've got a Congress that is not performing well, having an administration that's willing to dig in on these issues and take some tough decisions, frankly, is critically important to furthering our agenda. You know, the bottom line is, as these gentlemen said, you can't be prepared to litigate well unless you've got statutes that provide you with the basis for doing so. And whether it's the feds, it's the states, or localities, we have a responsibility, I believe, to ensure that we've got legislation that becomes good language for final statutes. And these roads can be very difficult, trust me. But at the end of the day, you know, we need to use every tool available to us in our Humane toolbox and be able to move in the best way to be able to provide for lasting opportunities for animal protection issues. And if you'll just give me 30 seconds of latitude, I blew through that pretty quickly because I want some questions here. But if you'll give me a little bit of latitude, This is my own, thank you. Animal protection issues do matter. They matter at every level of your government, and there has been no stronger approach to decimating what so many of you have worked on your entire lives and are looking forward to working on in your careers than this particular candidate for president.
They say a picture is worth 1,000 words. So what does this one say about a Donald Trump presidency? Trump's sons, they're trophy hunters of elephants and rare species. Don Jr. is floated to be Interior Secretary. Trump's agricultural advisors support confining pigs like this, allowing cruel puppy mills, even making horse slaughter legal. It's a frightening picture. A Trump presidency would be a threat to animals everywhere. Humane Society Legislative Fund is responsible for the content of this advertising.
Excellent. So we have about 10 minutes, I believe, although I know our valiant timekeeper will keep us on track. I think about 10 minutes for questions. Yes?
I know this is a huge issue. This is from Ms. Amundson. But I get about 20 emails a week about wolves.
Oh, yes.
Can you just speak a little bit about that? Red wolves and wolves in the Yukon.
Oh, I appreciate that so much. In my glossing over to rush through time to get to questions, one of the areas that I missed is part of us heading into this endgame with the U.S. Congress. It will likely take the form of something we call an omnibus or maybe a cromnibus, where they attempt to pass packages or a single package of appropriations bills to fund the government into the next year. We're living under a continuing resolution right now, but one of the major threats in that omnibus or whatever version it takes is pushing back our efforts to ensure that wolves continue to be appropriately listed and appropriately protected. And this is an odd scenario because it's a bit of a departure, frankly, with the Obama administration. It's not just a question of certain members of Congress in a specific party, but it is, frankly, the director of the Fish and Wildlife Service, Dan Ash, who believes that wolves have recovered, and it's both sets, recovered enough to be able to be essentially delisted, and that is very much a concern. If you'll give me a little latitude, that is an issue that we were fortunate to fight off in the previous omnibus. It was very much a hot button issue. We were incredibly helped by former U.S. Senator Russ Feingold from Wisconsin, who made it a campaign issue in essence and wanted to ensure that wolves continued to be protected. We have 3 other rules that are in process for being threatened. One of them is the new organics rule, which actually allows for outside opportunities for animals being raised as organic, and I apologize for my sarcasm, but I can't see how this is a problem in states like California. I understand there are concerns in Michigan. You know, it really is the sort of scenario where you want to ensure that you've got appropriate representations for all across the United States for outdoor access. The second one is clearly the Horse Protection Act. There was a letter that was led by Majority Leader Mitch McConnell, who lives obviously in Kentucky, and a few of his cohorts that went to USDA asking that the comment period be extended for 60 days. USDA gave them 30. So the comment period expires now on October 26th. USDA still has time because they're working on the rule now, taking the comments in and looking at what needs to be addressed to get that done, but that is threatened very much so. And then finally, back to wolves and so many other species. That's the decision that was made to provide for huge protections in Alaska for wildlife and, you know, bears and denning situations with their young and you name it. And given the strength of that tiny little delegation in Alaska, it is stunning to me, but there will be a pushback to try to roll back what the Obama administration did with that final rule.
Yeah, I have a question for Chris. For the zoo, You said the ESA only covered the endangered animals, so were those animals able to go somewhere else?
Yeah, she was ordered to surrender those animals, and this was like somewhat recently, so I don't have a specific update right now about where they went, but she was ordered to get rid of them, and we're still fighting over where we want them to go.
Thanks.
Yes.
Quick question, and just to answer your question, the panel before said that she had full discretion as to where those animals went, and they went to another roadside zoo elsewhere in another state, unfortunately.
Not the lions. The lions are.
Oh, yeah, the lions, right, those accepted lions.
Lemurs and tigers.
Yeah, lemurs and tigers. So I'm confused, I thought that the Soaring Act was already a federal protection.
That's why you got to write good statutes the first time. So it is a 40-year-old act. It was passed in 1970. We thought at that time that the strength that USDA had would address the considerations. Unfortunately, it was amended in 1976. And part of it was a resources issue, which created this third-party inspection system, which is a disaster. For those of you who followed the retail pet store rule, there was a thrust at one point in time to allow AKC, for example, to be the third-party inspection system that USDA would use. It is much like the HPA, where you've got the proverbial you-know-what watching the you-know-what. And the bottom line is, it is a sorry day, but that statute as amended really does require some updating to ensure that we're keeping ahead of the soaring community.
Hi, this question is for Sara. My name is Annie Weaver. I'm a third-year law student at the University of Tulsa. And right now, Oklahoma is trying to pass a constitutional right to farming, which we are fighting. 2 states have already passed it, I believe, one of the Dakotas and Missouri. Nebraska just pulled theirs, but Oklahoma is still going forward with theirs. And it seems to me that with each state and more public awareness, there seems to be more and more of a fight. So my question is, do you know if there are any other states that are trying to push that at this time?
Well, that's an interesting question. I would say as long as Forrest Lucas has money to expend on these efforts, there will probably be other sort of middle of the country states that look to it. What was interesting in Nebraska is they were attempting a constitutional amendment, and that was clearly not the direction that folks wanted to go. So that was a positive. Oklahoma is a hotbed. If we can turn this around, which we firmly believe we can, our 5-week media strategy starts about now, and we have caught everyone from the president of the Farm Bureau to the president of the Cattlemen's Association saying, no ifs, ands, or buts, the language is crafted and reaches too far. And this is really a situation where it's not right to farm, it is right to harm for folks in Oklahoma. Our team on the ground there is doing extraordinary work. Our spokesperson is the former state attorney general, Drew Edmondson, who is just on point, on message, and has lived this in terms of the grabs at water rights and all kinds of farming-related activities that have little to do with animal protection, but are part of the bigger picture as to why Oklahomans should be concerned. And I would just say, if you have any spare time, we could use you out in the field from the campaign office leading up to November 8th, but trust me, you're about to see sort of the strength of the no vote there. And the other thing that I will say is yes votes are one thing in ballot measures. No votes, all you have to do is create doubt. And so in this situation, we're just going to continue pecking away at creating doubt for rank and file Oklahomans who are voting that day.
Yes.
So in the Newcomb case, I think you were speaking a little bit about the owner's right to privacy and that not necessarily outweighing the animal's welfare. Is that something that could be applied to like cattle, for example, or chickens or hogs?
So this is where it gets tricky, and this is part of why it's important to look at our statutes. So again, where the court in Newcomb pulls that reasoning from is from Oregon statutes. So they're relying on the degree to which statutes protect animal welfare. And Oregon, as many states do, have exemptions carved out of cruelty code for various things. So cattle are not exempt as such. There's no portion that says cows, by virtue of being cows, are exempt from cruelty code. Cows may be exempt from certain practices. So certain agricultural practices will be exempt from cruelty. So the reasoning the court uses and the language the court uses is applicable to animals in general. The question is going to be, is that animal, as it's being held in custody by a person, whether that person is its owner or the state or someone else, is that animal protected by statute? Does the statute guarantee that minimum level of care that speaks to the animal's health and well-being? It certainly implicates that you could use that sort of reasoning in a livestock cruelty case. You just need to make sure that you weren't falling into a territory where the livestock activity was being exempted. I realize I'm getting away from the mic, I apologize. But we've certainly seen cases in Oregon involving episodes of people starving livestock, and so cruelty code can apply. It's just not always going to apply because it depends on the specific behavior. Yeah. And I think I'm getting the signal that is our time. So thank you all very much.